The 5th District Court of Appeals in Dallas, Texas is now in session. Justice Browning presiding.
Good morning, counsel. Thank you for being here with us. I think by now you all and certainly the justices on the court are fairly used to virtual proceedings, but should you encounter any kind of difficulties or have any questions, any technology snafus, please let us know as soon as possible. With that, I'm going to go ahead and call the case. We're now ready to hear argument. Case number 0519-01548 CV, Pure Gen Holdings, Inc. versus NEORA, LLC. Mr. Pearson, you may proceed.
Thank you, Your Honor. Good morning. May it please the court, Adam Pearson for Appellant Pure Gen Holdings. The district court erred in denying Pure Gen's motion to dismiss under the TCPA. Appellee's sole asserted claim is based on allegations that Pure, among other things, orchestrated a deceptive misinformation campaign through social media and gave misleading information through public advertisements. These allegations trigger the protections under the TCPA and required Appellee NEORA to present clear and convincing evidence of its claim. This it has not and cannot do, and therefore dismissal is appropriate under the TCPA. NEORA's primary tactic to avoid dismissal in this case is to portray the matter as a matter involving only private communications among business competitors. But that is not what is revealed in the first amended petition. This case is not like Dyer, Amend, or the other cases that NEORA alleges or cites in its briefing. This is a challenge to how Pure may advertise its products to the public and recruit its workforce through those same means. As a result, it implicates the protections under the TCPA and requires clear and convincing evidence.
Is the gravamen of this complaint about the products themselves that are in the marketplace or the marketing of the products in terms of misappropriating, allegedly, the workforce?
So if I understand your question correct, Justice Skank, is the gravamen about the marketing or about the way that the products are portrayed? Is that the question?
Yes. I mean, there's one thing about the product, which the public conceivably is interested in, but luring away the workforce in violation of non-solicitation agreements, how is that about the product?
Sure. Thank you, Justice Skank. So the gravamen of the complaint is that, again, by looking at the petition itself, what NEORA has alleged is a conspiracy that began with the way that it was portraying, that Pure was portraying its product as a competitor to NEORA's product, and that led to a process in place where Pure was able to solicit and recruit workers from NEORA's workforce in violation of the non-solicit agreements.
Okay, so would there be any claim here at all were it not for recruiting in violation of the non-solicitation agreements? What are the damages going to face if you go to trial and prevail?
Yes, Your Honor. Presumably, there could be allegations of defamation or something along those lines. Obviously, that is not a claim that has been brought. The claim is only tortious interference with the contracts that NEORA had with its own brand managers at the time. So,
has there been a public hue and cry over this dispute? Are the newspapers talking about it? Is Channel 4 all over this? Is it circulating on the internet? I mean, you know, is this a big tweet issue out there?
Well, I would hesitate to introduce anything that's not in the record. I will concede that there's nothing in the record noting main news coverage about this dispute or anything along those lines. I will, however, say that obviously, as we're all aware, traditional news is morphing. And so when we're talking about social media and the information that's conveyed through social media, much of the marketing and business that's done through companies such as multi-level marketing, like the companies at issue here, is done through means of social media, as was alleged. And obviously under the TCPA, what is required is only that it be a matter of public concern, not necessarily that it achieve a certain level of publication or news noteworthiness. If that answers Justice Whitehill's question.
Well, is there a difference between what the TCPA says and what the courts have construed it to mean?
Absolutely, Your Honor. If this court has obviously referenced multiple times the need for public involvement, and we had it in Dyer and multiple cases before, that there be some level of public involvement. I will say again, this is a very different case than Dyer and those other cases. Dyer, for example, involves thousands of private text messages, involved only 2 people. The other cases that are cited by NEORA primarily involve communications among only a small group of tortfeasors, whether it be in misappropriation of trade secrets, whether it be solicitation of employees in violation of a non-solicitation agreement. What you have here is completely indirect. The allegations include that there were actions taken through the public realm, through social media, about how products were portrayed and the company Pure itself was portrayed, and how that assisted in this solicitation of employees, allegedly according to the petition. And that puts this case in a very different realm than Dyer and other cases under the TCPA where there was no public involvement.
So, counsel, is it your contention that the fact that these matters were posted on social media platforms transformed this from a matter of private contract to a matter of public concern?
That's correct, Justice Browning. This transforms this matter because, again, you had comments about a good and a product in the marketplace, which specifically falls under the definition of public concern under the TCPA, which I have not covered, but again, just to clarify, we were talking about pre-amendment TCPA. So it's public comments about goods in the marketplace to consumers or potential consumers of that good. And so again, that puts it in a very different realm than private communications, as you had in Dyer and other matters.
Counsel, while we're on the topic of the social media postings, you had contended in your brief that from an evidentiary standpoint, the social media posts that were cited as evidence were not properly authenticated. I didn't see any case authority that you cite the court to, and are you familiar with what this court and others in Texas have stated with regard to the authentication of social media posts in case like Tienda and others?
Yes, Your Honor, and I recognize that was not cited in our briefing. The evidentiary issues, again, we do not view as necessary to decide this case, but obviously it was an issue raised in our briefing, and we think it was an evidentiary issue that was preserved before the trial court, and that there was an applied denial of our evidentiary objections on that matter. Turning back to the TCPA, I would like to just reiterate, there's obviously, as this court is well aware, there are various ways that the TCPA is implicated, obviously one through right of free speech, one through right of freedom of association. Discussing first about right of free speech, they do have different scopes. There is no challenge that the lawsuit here is based on Pure's speech. There's been no challenge to that, and it's obvious from the petition that involves speech allegedly engaged by Pure. The dispute is about whether that speech relates to a public concern. And again, as this court is aware, public concern is defined by the statute as, among other things, having to do with economic well-being or speech about a good product or service in the marketplace. I'd like to first discuss that because that is an obvious path that we think that the district court erred that triggers the protections under the TCPA. The speech at issue here, again, involves products, both NEORA and Pure's products that were in the marketplace. NEORA has challenged this on the fact that Pure's product, the specific product, was not specifically available for sale at the time that many of these allegations or many of these alleged speeches took place. that argument fails for multiple reasons. Number one, it is not only Pure's products that are at issue in this complaint. If you look throughout the complaint, there were also references to NEORA's own products, where NEORA has alleged that Pure's speech confuses the public with regards to NEORA's products. And so it's not only Pure's products that are implicated by the speech allegations in the petition, it is also NEORA's products. And there's no dispute that NEORA's products were in the marketplace at the time of this speech. Secondly, there is no support in the case law that a good is not in the marketplace within the purpose of the TCPA if it's not actually for sale available yet. The Supreme Court has defined this provision of the public concern of a good in the marketplace in creative oil and gas that states a communication falls under this definition if it has, quote, some relevance to a wider audience of potential buyers or sellers in the marketplace, as opposed to communications of relevance only to the parties to a particular transaction. The speech here fits that definition even if you're only looking at Pure's product. It's not disputed that Pure had begun marketing its good amongst the public through social media. It had engaged in communications with potential buyers and sellers. And the concern of the Supreme Court of Texas, of the TCPA as construed by the Supreme Court of Texas, is whether it's a communication that is reaching out to a vast group of potential buyers or sellers, or whether it is to a particular transaction. And that's the distinction here. Pure was not communicating with any specific buyers or sellers for a particular transaction. It was communicating to the public about a forthcoming product that was in the marketplace at the time. And therefore, for that reason alone, that triggers the protections of the TCPA and required that NEORA present clear and convincing evidence. Now, again, because that's enough, although that is enough on its own, I would like to also touch on a few other instances. Number one, economic well-being is also a matter of public concern defined under the TCPA. The speech here that Pure engaged in also implicates that right. Amongst the petition, NEORA has alleged that this deceptive misinformation campaign that Pure allegedly involved in was intended to, quote, mislead the public. And that's a quote directly from the petition. And again, economic well-being is defined as a topic that is subject of general interest and of value and concern to the public. The allegations that Pure is engaged in this campaign to, quote, mislead the public directly implicates that concern, the economic well-being of the general public. NEORA's argument against this is that, again, pulling on cases like Dyer, Amend, of that nature, that there must be some sort of public involvement. And we agree those cases stand for that proposition when you're talking about economic well-being. However, we have that here.
Let me stop you right there. To the extent we have panel opinions, this is not the first case, obviously, where we've interpreted this statute. To the extent we have panel opinions that are inconsistent with each other, in your understanding, which would prevail, the later opinion or the earlier opinion?
So, Your Honor, my understanding of the precedent is that, and obviously varies amongst the courts, is that it is the latest precedent that the court is supposed to follow.
What authority does this panel have to overrule Dyer or Amend?
Well, so Your Honor, I would say I don't think that you need to overrule Dyer. It's my contention that Dyer is distinguishable from this case, again, because we had something that addressed Dyer, which involved private text messages. To here, you have public communications that necessarily, because of the way that they're communicated, implicate a public interest that was not at issue in Dyer.
But my concern is a little different. I mean, if we have two people working at a company, and one says, let's put poison in a product and send it out into the marketplace, and a whistleblower puts that out there. The public hasn't heard it yet, but is that a matter of public concern? Even though it's not posted on a website or in social media or someplace else, I'm trying to wonder if, to the extent that requirement is consistent with earlier panel opinions, because I will tell you, my understanding is different from yours. I do not believe panels have the authority to overrule earlier panel precedent. And as a result, the first in time would prevail. And if it were otherwise, we wouldn't have an in-bank review mechanism. So do we have any prior panel authority that's inconsistent with Dyer in that respect?
Yes, Your Honor. And I will preface what I said with that was my recollection as to how this court treats prior precedent. I know it varies amongst the courts. I'd be happy to look into that and provide case law. But obviously, I would defer to.
I don't think I need it.
Okay, I would defer to Your Honor on that point. But I will point out the scenario that Your Honor proposed of where you had a whistleblower that, as I understand it, had not as of yet made information public. Again, when we're talking about the instances of Dyer, assuming that the public concern, we were talking about economic well-being, and that the issue that was that was the topic of the whistleblower had not met the other parameters of public concern. Based on the prior precedents, you did not have that public participation if it was only amongst the sole whistleblower and the two individuals. That's my understanding of the precedent. However, I would say that this case is closer to the McFarland case that this court previously decided in 2017, whereas there you had an allegation, and it mirrors the arguments of NEORA in this case, whereas that there's not a public interest in the communications because there was a private benefit, that it benefited Pure to allegedly disparage NEORA's products, and therefore it's not a public concern. This court has rejected that in the McFarland case, where you had an incident where an individual was posting critical reviews of products on a public website, and this court rejected the fact that the argument from the appellant that a defendant's speech is only if it's an attempt to attract potential customers, it serves a commercial purpose and is not a matter of public concern. This court rejected that. And simply because there may be a private benefit to the communication does not remove it from a public concern. I realize I may have wandered off a bit from your questions, Justice Gank. If I didn't answer it, please let me know. But
well, you did. Thank you very much.
Thank you.
Counsel, how do you reconcile or distinguish the authority that the Appellee addresses us to in the first and second notice of supplemental authority, the United Development case and the White case?
Yes, so Your Honor, again, I believe those cases, if you look closely at them, those are, and that's the primary disagreement here, is that NEORA portrays this case as along the lines of those cases where you have private communications among business competitors. Those cases involve private communications amongst a small group of tortfeasors and did not involve the allegations of public social media communications that perhaps indirectly had an effect on these private companies. In our briefing, we also touched on the right of association. I believe I've covered that quite a bit just in answering questions, the public versus private interest. But please let me know if you have any questions. I did want to touch briefly on the clear and convincing standard, because that has not been met here. Obviously, as this court is well aware, once the TCPA is triggered and the protections are implicated, the burden then falls on the non-movement to present clear and convincing evidence, and we do not have that here. The very first element of NEORA's claim, tortious interference with the contract, requires that they prove that there is a valid contract subject to interference, and they have not met that standard. We haven't even had specifications about what contract we're talking about. There was one branch manager or brand distributor, specifically Ms. Rowan, that was mentioned in the first petition. There's been no evidence to support what Ms. Rowan agreed to, how she agreed to it, that there's an executed policies and procedures contract that would be validly binding on Ms. Rowan. And so even for the allegations against Ms. Rowan, their claim fails the clear and convincing standard. Beyond that, with NEORA's allegations that Ms. Rowan engaged in interfering with the contracts of other brand manufacturers, we have even less. We don't know who those brand distributors are that were allegedly interfered with. We don't know how they entered into their contracts. We don't know how they agreed to the non-solicitation agreements and the policies and procedures. There is just simply no clear and convincing evidence to establish that there was a binding contract on those parties, let alone what parties we're talking about. And from there, I'll just touch briefly. Similarly, we have no evidence of a willful act of interference. There's allegations about how Pure perhaps induced Ms. Rowan to intentionally interfere, but again, we don't know what contracts are at issue. We don't know a specific act that was engaged in by Pure to interfere with those contracts, and the clear and convincing evidence standard has simply not been met. And for that reason, dismissal is appropriate.
Okay.
If there's no further questions, I'll concede the rest of my time for rebuttal.
Thank you, counsel. Ms.
Thank you.
Black?
Thank you. I'm going to stand as if we were in the courtroom, if that's okay. May it please the court. My name is Monica Lattin, and I'm here on behalf of the Appellee. There has been, as this panel's well aware, an avalanche of litigation over this statute. And it's important power not just to dismiss lawsuits soon after they're filed, but also because of the automatic stay. It's that automatic stay that allows a party who defeats a motion to dismiss to be stopped in their tracks. And that's why there are so many appeals from the denial of a motion to dismiss. It's unusual in Texas law. It's probably unusual in any law. But that's why we see so many of these motions. Here, the trial court found that NEORA well, frankly, the trial court wasn't specific in its finding, but that NEORA was entitled to proceed on the merits. And we've been unable to do that due to this appeal. The trial court was correct in its ruling, and I look forward to exploring that further. I do think it's important to note the purpose of this statute is not just to protect citizens from retaliatory lawsuits, but also to protect the rights of a person to file a meritorious lawsuit. The other overarching point I'll make is that most of Pure's arguments revolve around the fact that some of the statements referenced in the petition were made publicly or because they involve business, but that is not the standard to grant Pure the right to use this powerful tool to deprive NEORA of the right to pursue this claim. First and most fundamentally, the TCPA simply does not apply to this case. As everyone knows, Pure had a burden at the trial court. They had a burden to show by a preponderance of the evidence that the action was based on or in response to Pure's exercise of free speech or association, the two rights asserted here, and that the claim is factually predicated on the alleged conduct that falls within the scope of those defined rights. Importantly, we are to consider the pleadings as well as the affidavits. We don't often consider the pleadings. The Lipsky court to Texas Supreme Court noted that with notice pleading standard, a lot of times your petition can be pretty bare bones, and especially in defamation cases where these kinds of issues arise most frequently. But between them, they have to provide enough detail to show a factual basis for the lawsuit. Here we have a detailed petition and affidavits. We know they're reviewed in the light most favorable to NEORA. And as this court held in Rouzier, we review that in the light most sympathetic to non-applicability. That's effectively a presumption against the applicability of this statute. We know we can't blindly accept attempts by the movement to characterize the claims as implicating protected expression. And much of the briefing in this case is just that, very generalized statements that I will get into further. And importantly, on applicability, it's important to note that Pure submitted no evidence on this prong. It's relying entirely on the petition. The first issue I'll address is free speech. We know that the statute itself says that there must be a communication in connection with a matter of public concern. The question is what is being said. It's not a question simply of whether it's public or private. The question is what is being said. Now, the statute gives 5 examples of issues where public concern may arise: health and safety, environmental, economic, community well-being, etc., goods or services in the marketplace. Those are examples where issues of public concern may arise. But the content of the communication is the key. The content of the communication must relate to a matter of public concern. We know this is true since at least December of 2019, when the Texas Supreme Court ruled in Creative Oil and Gas. Creative Oil and Gas, they made clear this very important point, that a matter of public concern, the linchpin of this statute, is that the matter involves political, social, or other concern to the community. And the court made clear that types of communications in the statute don't paradoxically enlarge the concept of public concern. And went on at page 137 to note, not every communication related somehow to one of the broad categories in 270017 always regards a matter of public concern. The Eastland Court of Appeals in Blue Gold wrote a thoughtful opinion amplifying this point about communications do not become a matter of public concern based on the nature of the business. There must be some relevance beyond the interests of the parties. This court has held likewise. It had started to reach this conclusion, I believe, in Dyer, which predates Creative Oil. In Dyer, the court emphasized that public concern remains the critical issue. But Creative Oil leaves no doubt that that is in fact what we do. We scrutinize the very statements in issue. Many of this court's opinions do turn on fundamentally private communications. And this case involves a backdrop, as we use the term in the petition, a backdrop of some public communications. And the key linchpin of the claim is private. But public versus private, to me, is not the cornerstone of this case, though it's interesting and the case could easily turn on it. What we know is that the subject matter must be relevant to a matter of public concern. In Goldberg versus EMR, this court noted communications about purely private economic matters. In United Development Funding, the court said not every communication relating to the broad categories regards a matter of public concern. And just recently, as we noted in our supplemental authority, the White case authored by Justice Whitehill talks about how the communication must address a subject of legitimate news interest. That is, a subject of general interest and value and concern to the public. So earlier cases have spent a lot of time looking at purely private communications about purely private business matters, but public communications about purely private business matters would likewise not be a matter of public concern.
Why then would your petition be focusing on the public dissemination of information you claim to be defamatory? How would that not create a damage? The mirror image, at least, of the injury to your client would be the public perception of it with respect to the good in the marketplace, wouldn't it?
Thank you, Justice Schenck. It's important to note this case is a tortious interference case. And so we analyze the statement with their nexus to the claim and issue. We've not asserted a claim for defamation. We've asserted a claim for tortious interference. We do talk about the backdrop of the interference, but this claim, unlike many TCPA cases, is a tortious interference case. So there, to answer your question directly, there is no defamation claim in this case. Importantly, in White addressed both economic well-being and found that a communication about economic well-being that addresses private economic interests is not a matter of public concern. And likewise with goods and services, citing Creative Oil, citing Thomas versus BioT. That's the question. Pure says economic well-being and goods and services in the marketplace, but has never articulated how the content of the communications themselves have a nexus to the claims and address a matter of public concern. To go more deeply into each of those things, I'll start with economic well-being. It's important to look at the briefs in the opening brief, page 16. What did Pure advance to this court as the basis to reverse on economic well-being? On page 16, they said economic well-being is involved because they involve potential employment. but never said how that topic would be a matter of public concern. In fact, in the opening brief, the term public concern is only mentioned in the legal standard discussion, other than to say that private communications can qualify. But there's no argument to this court in the brief about how the topic of potential employment is a matter of public concern, and we know it's not. In the reply brief at page 5 to 6, though I submit that's too late to make your argument, all Pure says is the case undeniably involves issues of economic well-being. They say because of the public nature of the alleged marketing and recruitment, but that is not a matter of public concern. Marketing and recruitment is a private economic interest, and that's consistent with the cases over and over that talk about private economic interests. They do go on in the reply brief for the first time to mention the importance of exploring work opportunities without the shackles of unlawful restraints of trade. That's never been raised before. It's not in the record, and it's not part of any of the communications. There's no reference to that, so I won't spend any further time on it other than to note that was new. The second issue is goods and services in the marketplace. Again, the opening brief at page 16. What have they articulated? They say this qualifies for protection under the TCPA because the communications refer to Pure's skincare and anti-aging products. That is not an articulation of a matter of public concern. There is a threshold issue where we don't even have to reach this. It was Pure's burden to show in the trial court and in their opening brief that the goods in issue were in the marketplace. Now, being in the marketplace isn't enough, but we know we're talking from this court's precedent and from other precedent that is what's discussed, and in Creative Oil actually turned on goods not even being in the marketplace. And that's true here. Again, they're relying only on our petition. Every bit of the petition is about Pure's products, for example, paragraph 15 and page 9 of the petition, products launching in August, pre-launch, products that will be released. And Mr. Pearson acknowledged in his comments a moment ago, he used the word forthcoming. These are forthcoming products that Pure did not meet its burden at the trial court in the opening brief to point to the evidence in the record that this speech concerned goods in the marketplace.
What about NEORA's goods in the marketplace?
Well, 2 points about that, Justice Whitehill. First of all, that was never argued in the trial court, and it was not argued in the briefs, was not mentioned until today. So that is a new point. But I don't believe that is the nexus of the right that is at issue. I've not had a chance to think about it more deeply, but everything in their motion to dismiss all the way through has been about them promoting their products. The fact that they mention NEORA's products is, I would say, tangential. But the second thing I will add is that you'll see in the petition that what they're talking about are NEORA's old products. So NEORA had a divorce from its business partner that supplied certain kinds of products. This launch says they're back. The products are back. So they've not actually established, even if they had argued it, that the goods and services they were referring to were goods and services that were at that time in the marketplace. And if you look at the petition, the evidence talks about how their marketing strategy was to say, these goods are coming back. These are the original products. These are the authentic products. And so I submit they did not meet their burden to establish that, to identify it or establish it either below or in the briefing. I'll note that in their reply brief, where we challenged public concern, they still don't connect the dots. Page 8 to 9, they just say that they're not limited to private contract matter and are tangentially related to a matter of public concern. They cite the Wynn case, which I want to touch on briefly. The Wynn case does go on to articulate a public concern. It's really nice example in this case. It's not mentioned in the reply brief, but Wynn turned on the fact that the communications at issue were about a contract with DFW Airport, a public entity, and it was explicitly why the communications have public relevance beyond the pecuniary interests of the private parties. In sum, they've failed to meet their burden and cannot. Creative Oil is clear, and all of the cases since Creative Oil are clear that the content of the speech is what must be evaluated for true public concern. On right of association, they must show that these are individuals who join together to collectively express, promote, or pursue common interests. First of all, we've established, and they failed to establish to the contrary, Pure is simply not an individual. Texas law routinely distinguishes between individuals and corporations. In fact, a person is defined as an individual or a corporation. We know these principles well. We know these from looking at the statute itself. The TCPA uses the term persons in some places and individual in other places, and Pure provided no authority to conclude that an individual is in fact a corporation. It's of note that the TCPA has been amended since then to remove that restriction. And Pure cites opinions that applied the right of association to entities, but no opinion that addresses the question of whether the entity is an individual. So none of those cases stand for the proposition that an entity is an individual for purposes of the TCPA in effect at that time. Even so, Pure did not establish their joining together to collectively express or promote or pursue common interests. There was no evidence. And importantly, they failed to demonstrate the nature of the communications involve public or citizens' participation. They acknowledge that standard at page 20 of their brief. They acknowledge that we challenge it, but they do not establish it. There is no sentence in the opening brief identifying a public or citizens' participation. Instead, they focus only on the fact that the statements were publicly made. But posting something on the internet does not constitute exercise of the right of association. We know that the right of association is a much more specific thing, as the case law has established. They just conclude there was an undeniable component of public participation. There are cases involving Facebook pages of enthusiasts around a topic, Erykah Badu's music, horse interest. There's no evidence in this case that these postings were made to a forum of enthusiasts around some public issue like that. There's just no evidence. Again, they put on no evidence, and they cannot now argue that, and they've not established it even today. The Amond case says you have to show how the allegations involve public participation. And in White, a shared interest in a private business transaction wouldn't count. That's what these communications were doing. They were trying to promote the opportunity at Pure to join Pure and sell Pure's products. Gascamp importantly focuses on this issue of common interest, which is the definition in the statute, that it means of or related to a community at large or public. And that's right. That's what we all know the right of association to mean. The Blue Gold case talks about that as well. And it's true. There are no cases that disagree on right of association that have analyzed this definition of common interest. It's just not established. And I think it's clear in this case that this type of commercial marketing and recruiting is not a right of association. I want to briefly touch on the tortious interference claim. We did meet our burden. And we know that all that NEORA had to do was produce the minimum quantum of evidence necessary to support a rational inference that the allegation of fact is true. Circumstantial evidence is valid. Lipsky makes clear, Fan Expo makes clear that's common in tortious interference claims. I'll note the objections were not preserved. We've briefed this. There is no implied ruling because the trial court could well have stopped on prong 1 and stated in the order that the court only considered appropriate evidence. But also it's important to look at what objections they actually made versus objections that they've spoken about even in their reply brief that are just not preserved. That said, I believe NEORA well established in its petition and in its affidavits enough of a quantum of evidence to support its claims. On the existence of a contract, Ms. Wager testified without dispute, all brand partners, all of them, are subject to the policies and procedures. It is a precondition to becoming a brand partner that you must agree. She did not articulate how the tens of thousands of NEORA brand partners did that, nor was she required to. There are cases where there are disputed facts about that, where the court digs deeper. But Kiani makes clear you don't have to have specialized or technical knowledge. And in the Rutowski case they cite on reply, that affidavit had a hole. It said registration is generally accomplished online by checking a box. but it didn't say that that person had done it or if there were other ways how that could be done. This is all brand partners have an agreement not to solicit other brand partners. We established the merits of interference. We have a detailed recitation in our petition. I'll note it's not just Rachel Rowan who was accidentally replied on a blind copy email where she had a person in her downline and said, "You're free, congratulations," supports a rational inference that she is involved in recruiting that person to leave NEORA. There's also the Cassie Martin Facebook page in the clerk's record of 189. Those taking action will start earning right away. She's speaking to her team there. We established that Pure was aware of the contract in the letter from me. They don't dispute that. And we established damage or injury. In fact, the case law is clear. We don't have to have a damage model. The fact of injury from poaching a member of the sales force is actually the example of irreparable harm, and Ms. Rourke's affidavit established that as well. They did not establish their affirmative defense, and importantly, this case, if there were any question about discovery, should do what it did in Watson versus Hardman in 2016. We preserved the issue of discovery in our motion, so Minute versus Snowden does not apply. Thank you. I believe my time has expired. If you have no questions, I will pass to Mr. Pearson.
One additional question for both of y'all. What percentage of these TCPA cases was I not the author of or on the panel?
Not many, Your Honor.
I looked, and you're on a lot of them.
Oh, wow.
Thank you, counsel. Mr. Pearson, rebuttal.
Thank you.
Thank you, Your Honor. I'll take just a moment because, again, it's, as Justice Whitehill pointed out, I know you're all very familiar with the TCPA. I will highlight, just because it's top of mind, it was just reiterated by Ms. Lattin. This case may be different if we were talking only about emails from Ms. Rowan to employees of NEORA. It may be different if we had a situation where there were those private communications between employees and former employees. It would put it more in line with the cases of Dyer, Amend, and that nature. But that's not what we have here. Much of the argument that that Ms. Lattin presented and has been presented in the briefs is almost that the statements within the petition don't have a nexus to the claim themselves, but they are in the petition. If they don't have a nexus to the claim, they would not be in the petition. And is this?
You help me a little bit. I may have misunderstood your argument earlier. I haven't myself pulled the petition, but Ms. Lattin reminds me that the only claim being asserted by the plaintiff here is tortious interference. And I had heard you to, maybe I misheard, you indicate that there were specific allegations in the petition to the extent that communications that you had made were defamatory and been received by the public at large. Can you?
Yes, apologies, Your Honor. There's certainly not a claim for defamation. Ms. Lattin is correct. There's only one claim for tortious interference. I think I was referring to a hypothetical where if you had those claims or had those public statements, but here we only have tortious interference. But yes, there are, the claim is for tortious interference, but the method in how that alleged tortious interference occurred is what distinguishes this case from Dyer other cases of tortious interference. Here, again, you did not just have solicited emails or private emails recruiting employees or sharing trade secrets. Here you had public communications. Again, I'll just read from the petition. Pure orchestrated a deceptive misinformation campaign trying to conflate its product launch with NEORA's successful product line, NEORA's products Illuma Boost and Youth Factor to quote, mislead the public. And that's only one example, but the allegations in the petition, which is again evidence, it's not required of a movement under the TCPA to present more. The allegations are that Pure engaged in this deceptive misinformation campaign, and then as part of that was able to lure away NEORA's workforce through brand managers. But these have a nexus to the claim. They're in the petition and they relate to the alleged conspiracy or plan of Pure to draw away NEORA's workforce.
Let's assume I have a dispute with my neighbor. I think that his fence is encroached on my property. I buy a full page in the Dallas Morning News complaining about this fence encroaching on my property. Is that a TCPA covered matter of public concern?
That would certainly be a more difficult question, Your Honor. I don't know if that would fit with economic well-being. It certainly would not fit in the definition of a good in the marketplace. And that is, again, where I think the lines get blurred a bit with Ms. Lattin's argument about what exactly is a public interest. Again, the TCPA defines a matter of public concern, and one of those definitions that it provides is a good in the market. Speech that is about a good in the marketplace is a public concern. And it is clear that that is what we have here. NEORA is making allegations that Pure made comments in the public sphere, specifically about products, Pure's products, NEORA's products, which were LumaBoost and Year Factor. And I'll just point out in our reply brief, page 6, there were references to NEORA's products as competition with Pure's. That irrespective of everything else, which again we think meets the level of a public concern, this court need only look at, was there speech, and was that speech about a good in the marketplace? And that test is met here.
But to get to Ms. Lattin's point, isn't the content of the speech relevant as it relates to the claim before the court? When you have a contract between their employees that they say you were participating in breaching with them, how did the speech that the public heard relate to that claim? That's where their damages are going to come from if this case is tried, right?
Absolutely, Your Honor. Again, I would state there's a reason that these claims are in the petition. The allegation in the petition is that Pure underwent this campaign to harm NEORA, to then therefore make it more attractive for NEORA's brand managers to leave NEORA and join Pure. That it was a battle of the products. And again, I know my time is out. If I may finish this answer.
You may.
Ms. Lattin's correct. The content of the speech needs to relate to the public concern. But again, that's what we have here. The speech that is at issue, looking at the allegation in the petition, is about the goods in the marketplace. It's about NEORA's goods. It's about Pure's goods. And that relates directly to a matter of public concern, therefore triggering the TCPA. There's no further question. I'll thank you for the court.
Thank you, counsel. Thank you, Mr. Pearson, Ms. Lattin. Well argued, both sides. And the case is now submitted, and the court's opinion will issue in due course. Thank you very much for your time today.
Thank you, Your Honor.
Thank you, Your Honors.